Thank you, Your Honor. Obviously, the police reports are false. The question is, were they intentionally false, or were they mistakes, as the defense has said they might be? In order to find these defendants not guilty, there has to be some innocent explanation for their actions that amounts to some reasonable doubt.
Objection, Judge. That's a shifting of the burden.
That's overruled. I'm only going to consider appropriate evidence. I won't allow any burden shifting.
And we're not. It just has to be reasonable doubt. And there is no this is proof. The proof is beyond a reasonable doubt. There is no reasonable doubt. The argument is that these first, and you see that they throw up so much against the wall, so much of which is inconsistent, that they must do, because there is no innocent explanation for the false reports. First, you heard today that several times that the TRRs are not material. Not material? As Your Honor knows, from the general order, from Sergeant Snelling's testimony, those are the four that are used to describe the circumstance and evaluate the use of force by a police officer. The form, that's specifically what it's designed to do. It could not be more material to a police shooting. It is exactly what everybody looks to. He says that it's silly to think that they would block this investigation, and yet that's exactly what they did. They weren't afraid of IPRA, as those emails show. What they're talking about with IPRA is complaining about having 2-week suspension. IPRA was not what they were trying to obstruct. What they were trying to do is they were trying to...
evidence of that.
Yes, that's in the emails, Your Honor.
Overruled. I'm only going to consider evidence that's presented and arguments based upon those inferences. This is argument.
What they were doing is creating a false narrative for the investigation into a wrongful shooting, or whether there was a wrongful shooting. Now, I have listened intently, as I know you have, to now over 5 hours of defense argument over 2 days. And I've yet to hear the explanation for why the forms were completed as they were. That is somehow innocent, if we could look at Gaffney TRR1. Why didn't he write that he fled? He certainly fled.
Judge, objection to the relevance.
Overruled.
He certainly fled. Why didn't he? Here's the relevance, Judge. Why didn't he rightfully fled? Because fled doesn't justify shooting somebody.
Judge,
now,
didn't shoot anyone. Objection.
That's sustained.
Well,
just rephrase.
It's not, of course, it's not Mr. Gaffney. Mr. Gaffney, Officer Gaffney didn't shoot anybody. They're trying to justify Jason Van Dyke's shooting. So that is why, that's what Thomas Gaffney is doing. That's why he checks assailant deadly force. And now, again, throwing arguments up against the wall to see whether they stick. Here is what the defendants have done. Now they shifted to, and yes, Sergeant Snelling went through all of the categories of whether somebody is a resistor or an assailant. And that was the testimony about whether he said he was a resistor, fled, and he should have put something in other as armed offender. And that he was not an assailant in his view.
Objection, Judge. That's a complete misstatement of Sergeant Snelling's testimony with regards to Thomas Gaffney.
Mr. Safer?
That's exactly what he said. But let's talk about that.
I'll look at his testimony. I've got the transcripts. I'll
Well,
look at it. And I'll only consider what he testified to, Mr. Fahey.
Okay, so here's what he testified about, Your Honor. And keep in mind, if he is, whether he's an assailant or a resistor is sort of a predicate question. But the key question is whether that assailant, if he is an assailant, uses force likely to cause death or great bodily harm. That's the only thing that justifies use of deadly force. As Sergeant Snelling said, if this box isn't checked, then they are saying that the shooting was not justified. They check that box.
Objection. It's just a complete mischaracterization of his testimony and the evidence. He was asked about 41st and Pulaski. He's got Mr. Gaffney's TRR up there, which pertains to 40th and Karloff.
He does have Mr. Gaffney's up there, but the box is checked. Your objection is noted but overruled, and I will consider only the testimony that pertains to each defendant.
The box, so I'm not sure what the argument is with regard to Mr. Gaffney. Is he considering all of things at once, or is it only Karloff? Again, throwing lots of things up against the wall. When we get to the OBR, he's considering all of the incidents at once. But here it's only Karloff? I'm not sure what the argument is. At any rate, he checks this box to justify Jason Van Dyke's killing of Laquan McDonald. And Sergeant Snelling absolutely does not say anything about how Officer Gaffney would have been right to check that box. What he says is, well, it's so, at that point, if someone starts raising a knife, even though the police officer is in the squad, you would still characterize that person as an armed assailant, correct? Well, just because the officer's in the vehicle and he has protection of the vehicle doesn't mean that he can't characterize the subject as an assailant. Again, we're looking at the actions of the subject, not the subject alone. So if he's moving towards the vehicle with a knife in hand and the officer feels that an attack is imminent, even though he's behind protection, the officer can categorize the subject as an assailant. Okay. So that's what Sergeant Snelling's testimony was about. It had nothing to do with whether or not Officer Gaffney could check the box. Uses force likely to cause death or great bodily harm. How do you know that this is a lie? He tells you it's a lie in his grand jury testimony. He says, he said, did you believe, I don't want to misquote it, you never personally felt at risk of death or serious bodily injury from this offense. Is that fair to say? Pretty much. Because I was still in the car. Now, if he would have jumped in the car or pushed his arms in the car, yes, I would have. But given what you saw, but yes, no. Because like I said, I was still in the car. I had my vehicle to protect me at that time. This is the box that matters. Whether he's an active assailant, as Mr. Breen has talked about, as Mr. McKay talked about, as Mr. Fahey talked about, is besides the point. I mean, there is relevance to it, obviously. It has a place on the form. But the key is the checking of the box of uses force likely to cause death or great bodily harm. Thomas Gaffney swears under oath that he did not feel that that was not what happened. And yet he checks the box. So why? Why? Why does he do that? What is the innocent explanation for it? There is only one explanation. And it is that he puts down use of force likely to cause death or great bodily harm, because that's the only box that justifies shooting. It is now not a matter of opinion, not a matter of what reasonable minds differ. You know what Thomas Gaffney was thinking. He told you what he was thinking, and he filled out the form directly contrary to that. Then that was to protect Van Dyke, to match Van Dyke's TRR, to match Walsh's TRR. Van Dyke's TRR is submitted on October 21st at 4:41. Walsh's at 5:04. Gaffney's at 5:15. There is no room. It's not a matter of disagreement. It's not a matter of an opinion. It is a matter of getting the stories straight. That is official misconduct, obstruction of justice, and conspiracy. Okay. Now, let's talk just briefly about the OBR and what Mr. Fahey says about the OBR. If we could go to Gaffney's OBR. Of course, the address of occurrence is on Karloff. Now, for the TRR, he's only describing what happened on Karloff, apparently, but that's the explanation that Mr. Fahey says. But now, he's describing what happened all together. There's no evidence.
There's no evidence of
Right. There's no evidence.
Well, I'm looking at the,
It's very clear that he's describing what happened at 40th and Karloff.
Okay.
in the OBR you're saying.
Yes.
Okay.
Okay,
Then
that's, I can't see in the report right there.
Okay.
where
Could
what
you-
the address of occurrence
could you
is.
get the actual Gaffney OBR1, please? It says 40th and Karloff.
Okay,
Okay. If that's
that's
the
sustained at this point, but you can argue. Go ahead.
okay, if that's the argument, I just thought that Mitch Fahey was saying no, it's combined. Okay, but if he's describing what happened at Karloff, what is the innocent explanation for why he puts down number of officers battered or assaulted? 3. There are only 2 officers on Karloff, and of course McGilligan is not assaulted at all. Why does he put in that 8 other officers were present, when no other officers were present other than Officer McGilligan? Why does he put swinging knife, the exact same words that Walsh uses, that Van Dyke uses? Why doesn't he say pop tire? Why doesn't he say scraped windshield? Why doesn't he say stabbed at me? Because he is matching word for word Van Dyke's story and Walsh's story. So if he is describing what happened at Karloff, as Mr. Fahey just said he was, and objected to any argument otherwise, this is demonstrably wrong. There is zero innocent explanation for it. It is conspiracy. It is obstruction of justice, and it is exactly to get their story straight. He is guilty beyond any reasonable doubt. That is the only reason that he would have completed the report as he did, because he was obstructing justice. That his sergeant and lieutenant did not correct this is no evidence that he is not guilty of this. We have seen, as Mr. McKay eloquently put it, that of officers rallying around their fellow officers. That was rampant. And we see that from emails of sergeants and lieutenants as well. You have been given no innocent explanation. The proof is beyond any reasonable doubt that this was false, that this was an attempt to obstruct justice, and it was absolutely, out of every word in the English dictionary that he happens to pick, the exact same two words as Van Dyke and Walsh is no accident. When he describes the events as popping a tire, stabbing, slashing, scraping, whatever, that is no accident. It is powerful evidence of intent. It is powerful evidence of conspiracy. There is no basis to find him anything but guilty beyond any reasonable doubt. Mr. Officer Walsh is very similar. There is no again, if we go to Walsh TRR1, please. Thank you. Mr. McDonald, flat. He's walking away from the officers. He's not listening. He's walking away. There is, as I tried to write down exactly what Mr. Green said about this. He said, nobody was battered. No one was justifying Jason Van Dyke's actions by claiming there was a battery. They did. Please do not be, there's a lot of talk about these points. Please do not be confused about the officer battery report versus the TRR with regard to battery. The officer battery report has a line that says number of officers battered. And that includes, apparently, also numbers of officers assaulted, or certainly could be interpreted that way. The TRR has no similar flaw here. In the TRR, if they are going to say, they could say assailant assault. And there is no reason for Officer Walsh to have put that down. Because Laquan McDonald is walking away from him, and I will talk in a moment about what the video shows, and why it shows that not as a difference of opinion, but why the evidence is clear that Officer Walsh did not feel that there was an imminent threat of battery. But let's assume for a moment there was. What, in 5 hours of argument, what explanation did you get for why they checked battery? They all three do it. Van Dyke does it, Walsh does it, and Gaffney does it identically. They put battery, not that this is an armed assailant, that has nothing to do with that. It is that there is a battery. And then, of course, he checks the final box. Uses force, not the assault, which maybe there's some, you could think that somebody would think something that they were afraid of. Not that. It is assailant deadly force. Uses force likely to cause death or great bodily harm. Uses force. That is the only way that deadly force can be justified. Let's look at that CPD Order 13. I've got it up here. If you could punch that up, Jim. It is, so this is the general order that was quoted for you by Mr. Green, G030202. And it's the use of force model. If we could go to the I think it's the third page, so maybe the fourth page. Okay. So this is under Roman numeral 3C is a definition of assailant, and Mr. Green quoted from C2. Actions likely to cause physical injury. Included in this category of assailant may be a subject who is armed with a deadly weapon and the subject fails to disarm, thereby making the subject's actions likely to cause physical injury. So that's the assailant assault box that you might check in that event. The appropriate response items when dealing with this category of assailant are those listed 3A, 3B, 3C1. Not deadly force. Not deadly force. So if there was some reason for this, again, and that's the difference between armed assailant and uses force that will likely cause death or serious bodily injury. That's a whole different category. That's number 3. Actions will likely cause death or serious bodily injury. An assailant in this category is one whose actions will likely cause death or serious physical injury to another person. In addition to the response above, firearms and other deadly force are appropriate when dealing with an assailant whose actions will likely cause death or serious physical injury to another. That's the key. Whether they are an armed assailant, whether he was somebody who didn't put down the knife, none of that justifies the use of deadly force. What they had to check in a box on the actual form that is used to justify a member's force is to check that box that says the assailant used deadly force or force that would cause serious bodily injury. He did not. Now, Mr. McDonald is walking away. Yes, he turns his head towards Officer Van Dyke and Officer Walsh, as Officer Van Dyke and Officer Walsh are advancing towards him. He did not turn his head suddenly, and Jose Torres did not say that he turned his head suddenly, and his testimony was, what did you see him do, if anything? He just turned his head in their direction to look at them. He did not say suddenly, and the videotape does not say suddenly, does not show suddenly. Now, as, again, throwing things against the wall, to make this, if we can hold on for a second, to make it be something other than it is. You heard Mr. McKay say, first of all, he's showing the officers the knife. Keep going. Thank you, Jim. So, yeah. So he is pointing it at that point away from the officers, not towards them. Then, hang on one second, Jim. Then Mr. McKay says that, well, you'll see that once Mr. McDonald gets to the dotted yellow line, he starts walking parallel to the dotted yellow line. It's just not true, Judge. He is shot on the other side of the dotted line. Objection. He's on it.
Your objection's noted but overruled. I can see the video.
This
is argument, reasonable inferences, is invited comment as well.
He is walking away from them. Turning his head is not using deadly force. Not threatening, not maybe there's an assault. Using deadly force. Judge, they are trying to say that what you see with your own eyes isn't what happened. He's walking away. They are walking towards him. Just like you have Mr. Gaffney's sworn testimony that he did not fear, that he did not fear the use of deadly force, you have Mr. Walsh's actions. He is walking towards Mr. McDonald, not away from him. He is not shielding. He is not maintaining a safe distance. He is walking towards him. That tells you he is not afraid of him. He is not afraid of an assault. And there is no construction, none whatsoever, under which he can say that Laquan McDonald used deadly force. It is only that justifies the killing. And that is why he checks the box. That is why he lies. And that is why he commits conspiracy. Mr. Breen says consensus is not conspiracy. It is when the consensus is to lie, to obstruct justice. What is the explanation for 3 demonstrably false, identical TRRs? 3 demonstrably false, identical OBRs. There is no innocent explanation. It was not, people perceive things the same way. Officer Gaffney isn't even perceiving the same event, isn't even at the same place, and his report is identical. There is no innocent explanation for it, absolutely none. It is because they have conspired together. Could we go back to the Walsh TRR1? Again, throwing things up against the wall to see whether it would fit. Can we go to the real one? Because you heard Ms. Breen say he filled out a TRR now because he used force, drawing a weapon. Well, you will see that there is a form that can say members respond, and all that he does is he fills in member presence and verbal commands. Doesn't say that, doesn't put down that he drew a weapon, and that, of course, doesn't check firearm and say drew. So that is just making it up as you go along. That is just trying to offer an explanation for what is inexplicable. And what is inexplicable is he shouldn't have filled out the TRR. Walsh, like Gaffney, is lying to protect Van Dyke and stop him from being prosecuted. That is official misconduct. That is obstruction of justice, and that is conspiracy. Let's talk about Mr. March, Detective March. He says, well, there's only one line out of 116 pages. Of course, another red herring. Many of those pages have nothing to do with any description of the event. They are ministerial acts. They are forms. They have nothing to do with a description of the event. As Mr. McKay accurately says, there are 2 places where he describes the events. But even before that, from the earliest moment at the scene, why did March shape the false narrative by framing this as an investigation of an assault by Laquan McDonald instead of a homicide by a police officer? So let's assume whether or not he ever reviewed Fontaine case incident report, not on that night, but ever reviewed it, he told her what to write in it. And Mr. McKay elicited from her that there's nothing wrong with that. That's routine, that she needed to get information from the detective, and that's right. But he characterizes it as an assault, an aggravated assault, not a homicide investigation to see whether it was a justifiable homicide. He shapes the false narrative, and from the very beginning, he lists Laquan McDonald as the subject and the officers as the victim, not Laquan McDonald as the victim. And that is ironic, as McDonald is either in an ambulance or in the hospital, breathing his last breaths. Defendant March is telling Fontaine to record the officers as victims. That is ironic as best and tragic as worst. And it is a crime either way, because it is a criminal attempt to obstruct justice. He then goes about trying to twist the evidence through false statements and affirmations of false statements to protect Van Dyke. You know, and by the way, with regard to Fontaine Case Incident Report 1, what we do know is that Detective March prints it and puts it in the permanent retention file. What we do know, and Mr. McKay says he's just a reporter. He's not just a reporter. If we could go to case sub 2, and again, Mr. McKay appropriately deals with what is on page 20. Maybe it's 19. Here it is. The recovered in-camera video from beeps 845R and 1813R was viewed and found to be consistent with the accounts of all of the witnesses. That is not reporting. And that is not opinion, Judge. That is a lie. Mr. McKay is absolutely right that educated people disagree about certain things. But now, this is a blatant lie. This is not anymore about the dark side of the moon, what you can't see, or a limited perspective. What Detective March is saying to anybody who's reading this report is you don't need to go look at that video because it is consistent with what everybody says.
Objection. That is not even a reasonable inference from the evidence.
That's overruled.
Who are the most important? Who is the most important witness who he takes a statement from? It is Officer Van Dyke. And what does Officer Van Dyke say? Could we go to, it's going to be towards the beginning. No. Let's go back. Right, thank you. On page 9 of case sub 2, if we keep going up, he says McDonald raised the knife across his chest and over his shoulder, pointing the knife at Van Dyke. There is no difference of opinion about that, Your Honor. It didn't happen. The video shows that is a lie. In defense of his life, Van Dyke backpedaled and fired his handgun to stop the attack. This is the essence of the entire statement. This is why he fired. First of all, he did not backpedal. He advanced. He did not do this to stop the attack. There was no attack. Think for one moment, Your Honor. So what Detective March says is that the video that the video is consistent with this. It directly contradicts him on the key facts. This is the person who shot, and his version is demonstrably false. And Detective March says it is true if you look at the video. Now let's look at Walsh. And that's just the very next page. Page 10. First, he starts by saying, Walsh related the same facts as his partner, Officer.
Judge, and I have to object, arguing this Joe Walsh statement substantively once again. It's a statement of David Marsh. It's not a statement of Joseph Walsh.
Your objection's noted but overruled.
He says Walsh related the same facts as his partners, and we already know those are lies. Officer Walsh also backed up, attempting to maintain a safe distance between himself and McDonald. That is absolutely untrue. That the video shows, and that's not the Dunkin' Donut video he's talking about. This is consistent with 813R. That is false. It shows that Officer Walsh advanced towards Mr. McDonald, not away from him. Now, when McDonald got to within 10 to 12 feet of the officer, he swung the knife towards the officers in an aggressive manner. And Detective March is saying that the video is consistent with this. It is not. It doesn't show that at all. So those are the two most important witnesses in this entire investigation who are directly contradicted by the objective evidence in the case. Now, Your Honor. Now, imagine for a moment that Detective March is not writing a report about a police officer shooting someone. Imagine he is writing a report about just an everyday average criminal who is accused of shooting someone. Imagine how he writes that. Imagine what he says. If videotape evidence of the shooting directly contradicts what the subject, what the person under investigation said about the key moments of why he shot. Imagine what that report would read. You know what? It would say in that when he is not reporting events, but when he is describing how the video compares to the key witnesses' statements, he would say the key witnesses' statements are directly contradicted by the objective evidence. Directly. And that would be a huge matter.
There's no evidence to support this argument at all.
Your objection is noted, overruled. It's argument and reasonable inferences.
Of course, he would highlight the lies and inconsistencies in that report. That would be critical evidence against just a normal defendant. Why isn't that here? What is the explanation for this lie? There is one explanation. He is obstructing justice. He is committing official misconduct. He is part of this conspiracy to protect Van Dyke. There is no other explanation for saying that the video, which directly contradicts everything that is important about what Van Dyke says, is consistent with what Van Dyke said. Mr. McKay says, well, he talked to Thomas Gaffney. He talked to Joe McGilligan. Thomas Gaffney testified that he did not fear deadly force. Joseph McGilligan testified in this court that he never felt like he was a victim of an assault. He never felt in danger of an assault from Laquan McDonald. That's what he testified. So why is he a victim in Detective March's report? Why? There is only one reason. that he was trying to protect Officer Van Dyke. He was trying to paint this as something that it wasn't. And it was not an assault. It was not use of deadly force. And it was not justified. And Detective Marsh knew that. And he lied. He lied to Earl Briggs. I'm not going to go back over that. He lied to Dora Fontaine. He is guilty beyond any reasonable doubt. The defendants, again, in this no coherent defense, point to Rudy Boreas. And Mr. McKay says Rudy Boreas wasn't highlighted. How is that? Because Rudy Boreas has absolutely nothing to do with why the officers acted as they did that night. That's what the investigation is about, not whether Laquan McDonald wasn't going to be put on trial. Laquan McDonald was dead. The investigation should have been, was this a justified shooting? Why did the officers do what they did? What were they thinking of? What did they know? What did they do? They knew virtually nothing about Rudy Boreas. Why wasn't he highlighted? Because it is a total red herring. What they knew at the time was that Rudy Boreas had reported that Laquan McDonald was breaking into trucks and was holding it. That's all. That's all. And that March talked to him later is still irrelevant with regard to what the officers knew and why they acted as they did, which was what was under investigation.
Objection, Your Honor. It's not irrelevant to David March and his stops 5 months later.
Your objection's noted but overruled. This is argument.
It is.
You get a second chance at closing, Mr. McKay.
And it is absolutely irrelevant to David March because the investigation that David March is conducting is whether or not those officers acted appropriately and whether that was a justified shooting. It can't be justified by something that Detective March learns 5 weeks later that those officers didn't know. That's why it's relevant to Detective March too. Mr. McKay says, well, you can shoot to prevent the escape of someone who's committed a forcible felony. Again, just throwing it up against the wall to see what sticks. Here's the problem with that, Your Honor. Nobody says that. The TRRs, they don't check fled, and we shot him because he fled. They said he shot him because he used deadly force, and of course he didn't. That Mr. March collected the shell casings. It proves that he had no intent, Mr. McKay says. Joseph Van Dyke emptied his clip. There was no question about whether there were 16 shots fired. Whether Detective March is not, nobody is asserting that Detective March is an unintelligent man. He's not going to deep six shell casings when everybody knows that there were 16 shots. He says he made sure the evidence techs did their job. There's absolutely no evidence of that. Zero. He records what the evidence techs did. There's no evidence that he was making sure that they did what they did. And as Ms. Holmes told you, there is no way he could have deep sixed the videotapes and gotten away with it. Now, Mr. McKay asks, where's the evidence? The reports hampered the investigation. Of course, as Your Honor well knows, the law of obstruction and the laws of conspiracy is that the goal of obstruction and the goal of conspiracy need not be obtained. Indeed, it never is, because people are called to answer for obstruction only when their obstruction fails. So the fact that it did not succeed is nothing. is no evidence of anything. As to Jose Torres, Your Honor, he testifies that he is bifocal point. In the evidence is focal point video 2. You can see his car. While we pull that up, I want to make something clear, just so that Your Honor is clear, because Mr. McKay said, well, they're blaming Detective March for not interviewing Jose Torres. That's not what we're saying, Your Honor. It's just that Jose Torres and Jose Torres and anybody who looks at this video sees the same thing, which is directly contrary to what the police officers see.
What video is that?
This is focal point 2, FP video 2.
And Judge, if I might object, the indictment in this case charges all of us with failure to interview these witnesses. So they may not be arguing it now, but that's what we're charged with in this case. If they're going to abandon it, it's fine. That's at least 4 paragraphs of the indictment.
Okay, your objection's noted, but overruled.
Okay, so there's Laquan McDonald. And there is Jose Torres. So that is where he was, for whatever it's worth. The point is, how does that in any way create reasonable doubt? Mr. Torres sees what anybody who looks at that video sees, that Laquan McDonald was not attacking them. This entire case, Your Honor, the entire case asks you to disbelieve your eyes. It asks you to say that a person who is walking down the street, yes, he has a knife. Mr. McKay says they don't want to talk about the knife. Ms. Holmes got up here and said that McGillicott repeatedly, for blocks, told him to put down the knife, and he didn't. He didn't put down the knife. He was walking down the street, and he did not disarm. And the general order says, and these officers know, that is not grounds to shoot him. It is not grounds for deadly force. He was doing things that were illegal. He's not on trial here. Unfortunately, if things were done correctly, he would be on trial for those crimes. That's what the law required, was that he be brought to justice, not that he be murdered on the street, and not that these officers cover it up. They are trying the wrong case, Your Honor. They're trying the Van Dyke case. That's not this case. That's another jury has determined that case and determined that it was a murder. That has nothing.
That's sustained.
Well, I think Mr. Hughes said exactly that in his argument.
I think you're objecting to that it was murder versus second degree. Is that
Yeah.
right, Mr.
Okay.
Reasonable belief, yes.
No, they found that he had no reasonable belief. But at any rate, the defendants argue that this is a difficult and dangerous job, and that there are split-second decisions that must be made, and that hearts are pounding, and that's all true. Nobody is denying that. It is a difficult job. But there were no hearts pounding when these crimes were committed. There was no adrenaline flowing. There was no danger. There was no split-second opinion. And they had the benefit of hindsight. They are sitting in the office filling out these reports. They could view the video. Indeed, they were viewing the video. And they had Mr. Green's video replay available to them. This case is not about the decision to shoot. This case is about what these defendants did in the calm, cool, reflective atmosphere of their offices, and how they got their stories together and conspired to obstruct justice. You heard a lot, Your Honor, about how these are good officers, good men, And maybe that's true. You are not judging these men. That is, you are judging their actions. And their actions were criminal. We are not contending these are evil people. But it is undoubtedly true that all that is necessary for evil to triumph is for good people to do nothing. And in the face of evil, a second-degree murder, these men went much further than doing nothing. They lied about what happened to help evil triumph. The case is not about a split-second decision. And they are not damned if you do, damned if you don't. They are not on trial for murder. They did not shoot. So they're not being damned for shooting. They're not on trial for murder. And they would have been fine with what they did. Indeed, our witnesses, we called our witness to applaud what some of the police work was on the street. That doesn't matter. What matters is what they did when they lied. There are lots of criminals who do lots of good things. And right before somebody commits a crime, they are not committing a crime. But then they do, just like this case. This case is what happened after the shooting. And with the luxury of time and perspective, we know what happened on October 21st. These three men lied in an effort to prevent that murder from being prosecuted. And that is an abuse of their office. And that is official misconduct. That is obstruction of justice. That is conspiracy. And this case is not only important to the defendants, but to the people. They did abuse the public's trust. They abused their office. They violated the law. There has to be a consequence for that, Your Honor. No matter how much we appreciate police officers, no matter how much we understand and appreciate the danger they face, when police officers violate the law, they must be called to answer for their crimes. They cannot escape the consequences of their actions because their job is noble. They cannot escape the consequences of their actions because they did certain aspects of their job well. They cannot escape the consequences of their actions by trying this case to you. You get the final word. Your voice is going to be the last one that will be heard. Then closing this episode, you will decide whether these police officers have a license to lie about what we have all seen on that video. You will decide whether these officers get to say day is night, right is wrong, walking away from a police officer is attacking them, using no force is using deadly force, turning to face an officer is the use of deadly force. No matter how hard it is, no matter how painful it is, you must find these three defendants guilty because they are guilty beyond any reasonable doubt. The law requires it. Justice demands it. Our society depends upon it. Thank you.
Thank you, Mr. Safer.